Good morning, it's Air Talk. I'm Larry Mantle. I hope you have a wonderful weekend in store. I'm sure you've been working hard and deserve it, and hope you get some much-needed rest. Well, you better get set for a TV battle of financial titans later this year. It'll be trial lawyers versus the medical and insurance companies. Their target, a November ballot initiative that would increase maximum medical malpractice awards from $250,000 to more than $1 million. It would also require drug and alcohol testing of doctors. Both sides of the initiative will spend tens of millions trying to convince us of their positions. Unfortunately, negotiations on a compromise that would have spared us this exhibition didn't pan out. With us is the backer of the initiative, Jamie Court of Consumer Watchdog. Jamie, good morning.
Good morning, Larry.
Monday of this week, you turned in 830,000 signatures. Just over 500,000 are needed to verified for qualification. Is this all but officially on the ballot?
Well, they have to be counted, but we had plenty to get on the ballot, and we think we'll get on the November ballot. I take a little issue with the characterization because, we had 7-8 patients there who had some real significant problems, and I don't know that we're going to spend tens of millions of dollars.
Really?
There's no question that lawyers are helping us, but I got to tell you the power of what happened to these people. Losing children, and the maximum value of those children's life is $250,000. People who were victims of high or drug doctors. I mean, the power of their story, if the public hears it, and thanks to NPR and thanks to the internet and thanks to TV, the public will hear it. I think we can beat whatever, and I think the other side will spend $80 million. They've already put in $31. But this is really David versus Goliath. This is patients versus doctors and hospitals. There's no question there's lawyers who will help fund this, and there's no question there are insurers on the other side who will help fund the other side. But I got to tell you, the power of what I witnessed and the fact that doctors now won't even discuss whether or not they should be drug tested when we know from the California Medical Board that 1 in 5 doctors over the course of their career has a substance abuse problem. They won't show up today. They won't show up on TV to discuss drug testing. I think that's a real sign that they don't really want to deal with these issues.
Well, were you willing to accept Senate President Darrell Steinberg's compromise proposal of a $500,000 cap?
I absolutely was not, but I'm not the proponent of the measure. A guy named Bob Pack, who lost his 2 children to a tragic case involving overprescribing by docs, to a driver who swerved off a road and killed his kids, who were just innocent victims. He, I don't think, was either. But the trial lawyers, who were part of our coalition, were willing, and we were very frustrated by that. But remarkably, and I think thankfully, the doctors refused it. This is 38 years ago they sat this $250,000 cap on injuries that don't involve wage loss or medical bills. So if a child dies or a senior dies or a homemaker dies, and they're not willing to move 1 inch, they're not moving to 500, they're not willing to move to 255.
Well, let's hear from the other side on this. Healthcare attorney at Fenton Law Group in Los Angeles, Benjamin Fenton. Thank you, sir, for joining us.
Good morning. Thank you.
Yeah, is that true that the physician and insurer side wasn't willing to accept the $500,000 cap compromise?
Well, I don't know if they came out with a formal position. I think they're concerned with any effort to raise the cap, and I think that from my perspective as an attorney who frequently represents physicians and all sorts of issues and see what goes on in their practices, it's important to recognize the effect that this would have on the physician community, because the physician malpractice rates will skyrocket. Those fees are going to be will trickle down to patients. You're going to have physicians in smaller communities who are put out of business. So I think it's important when you consider this measure to think about how it's going to affect the medical community, which provides care to the whole state.
But when this was originally passed in 1975, the $250,000 cap, if you were to adjust that for inflation, wouldn't it be over $1 million today?
Well, it would obviously have gone up, but what should be known is that there is plenty of avenue for economic relief in malpractice lawsuits. So patients are entitled to all damages. They're entitled to all medical costs, all future potential earnings. So this is some additional measure that I think is being pushed largely by trial attorneys. What it's going to do is effectively will increase by a vast number the amount of malpractice cases, because you'll have a number of attorneys who take these cases on what's called contingency fee basis, where they get a percentage if they collect. and it's going to make them a more aggressive bar. Now, I think there's obviously a great usefulness for that bar, but it needs to be tempered to some respect. I think it'll have negative effects if this limit is raised.
Jamie Court, a consumer watchdog, Diedrich Healthcare studied how much was paid out in malpractice cases, found that California doctors and insurers paid out $274 million in damages. Is there really a problem getting attorneys to take on these malpractice cases, given that California's one of the biggest payout cases in the country?
That's a phony study. It's not true. If you look at the National Practitioner Database, which the LA Times has done, we do have an unbelievable problem with access to justice, and it's particularly when you have children who die, and the people who talked at the press conference. If a child dies from malpractice, no matter how egregious, I don't care if it's a drunk doctor, I don't care what happened, it's a $250,000 case. And to bring that case, the costs for the attorney and the fees which come out of that award are so great, and the way these companies fight these victims is so great that you will not find an attorney in the state for most of these cases if a child dies or if a senior citizen dies. And, we had one woman who paid out of her own pocket for the death of a daughter, which I thought was a decent case. She lost, and then the malpractice insurers coming after them for $100,000 for their costs. So we know it cost them costs. This is expert witnesses. This is cost. This isn't even their attorney's fees, $100,000 to defend that case. So there is no economic way when the awards are $250,000 that people who don't have a lot of wage loss can get an attorney. And the big problem is
then how are these
that leaves the wrongdoers from being brought to justice.
So how are damages being paid then if people can't get attorneys?
They're being paid in cases where there are a lot of medical bills. They're being paid in cases where there is wage loss. But there is an unbelievably low number of medical malpractice claims in California compared to the country. Most other states, or half the other states, do not have caps on damages. Florida just removed its caps on damages. So, we are at a disadvantage in terms of the quality of care here. And by the way, we're not talking about lifting the cap. We're talking about indexing it for inflation to 1.1 million. That is, for a case, for an egregious case where a child dies or a senior dies or a non-wage earner dies, that's not
okay.
Extreme in today's dollars.
Benjamin Fenton, the Attorney General's initiative language seems to highlight doctor testing and enforcement of monitoring over prescriptions. The malpractice cap seems to be comparatively buried. Why didn't your side challenge that initiative summary?
Well, I think that the suggestion that there should be testing of physicians is strongly opposed by the physician community and the California Medical Association. The idea that physicians are abusing medication and so forth, I think, is just some publicity stunt that's being pushed by a particular group to kind of put pressure on physicians. And going back to what this gentleman said earlier, what's going to happen with respect to raising the bar, just to deal with that issue, is that it's going to increase the number of malpractice lawsuits significantly. The one area in California where we're inundated is attorneys. I'm an attorney, and I know that there's not a lack of malpractice cases. So raising that will just increase the number of lawsuits. And the idea that there needs to be testing of physicians, I think, is just ridiculous. There's not testing of other professions in society and doctors.
Well, there absolutely is. There's testing of janitors, Walmart workers, bus drivers, pilots, athletes, tech. Most people are drug tested.
But isn't that when they take
lives in their hands?
Isn't that when you're talking about employees, though, in a standard workplace? Isn't that when they accept the job as part of going through the employment process?
We follow the federal transportation rules, and for transportation workers,
I understand transportation, but that's different. They're dealing.
Yeah, right. They're holding people's lives in their hands, and that is true with doctors too. 1 in 6 physician disciplinary actions taken by the California Medical Board, the state medical board, during the past decade was for either physician substance abuse or physician overprescribing, the two substance abuse issues dealt by in this measure. The California Medical Board said in its own report that over the course of a career, nearly 1 out of every 5, 18% of physicians have substance abuse issues.
Okay.
And I can tell you, working with the victims of those physicians, that there is absolutely a problem. And if we can save one life by random drug testing, we should do it. And it is a patient safety crisis.
So, Benjamin Fenn, what's the best way to deal with that, doctors under the influence?
Well, the medical board, I'll regularly represent physicians before the medical board. The medical board is aware of these issues, and they're regularly looking at doctors who have had instances of DUIs, for instance, and they handle those cases accordingly. Doctors need to be held in some level of esteem. They do such significant training. They play such an important role in our society, and the idea that we want to subject all doctors to drug testing just because this gentleman can point to one or two cases where something may have happened, I think is really unfortunate. I think there has to be a sense that these doctors are sacrificing their lives.
Okay. Gentlemen, I appreciate we're out of time. I need to break off the conversation, but this is just part of what's going to be a continuing conversation on this program. This is a big ballot measure. It is not officially qualified for the ballot yet, but more than 800,000 signatures turned in by supporters of the initiative would seem to put the odds of it being placed on the November ballot in its favor. My thanks to Jamie Court, president of Consumer Watchdog, Benjamin Fenton, healthcare attorney based in Los Angeles. Doug in Irvine writes on the page, I favor raising the cap, but the proposal to require licensed professionals to submit to random drug testing is a patent violation of the constitutional right to privacy. In California, Tom writes on the page, if $250,000 was a valid figure 38 years ago, it's preposterous to claim it's valid today. Tie it to inflation and be done with it. Share your comments on the Air Talk page, kpcc.org.